July 1st, 2016, the Utah Supreme Court issued its decision in re Baby Q. A link to that decision is provided here, as well as in the description section of this video report. Phillip J. James, according to a voluntary acknowledgment of paternity, is the biological father of the child known as Baby Q, a girl who was adopted. Mr. James sought to intervene in the adoption proceeding, but the district court denied his motion. The district court found that James had failed to take the actions needed to preserve his ability to contest the adoption within 30 days of receiving a pre-birth notice informing him that the child's mother intended to place the child for adoption. James appealed from the district court's order denying his intervention. The Supreme Court resolved the appeal based on James's arguments that the notice he received did not meet the requirements of the Prebirth Notice Statute. Those arguments required the Utah Supreme Court to interpret the statute, and they therefore present questions of law, which are reviewed for correctness. The Utah Adoption Act includes the Prebirth Notice Statute. The Prebirth Notice Statute allows an expectant mother, a child placement agency, or an attorney representing either the mother or a prospective adoptive parent to provide formal notice to an unmarried biological father that the mother is considering an adoptive placement for the child. Upon receipt of statutory notice, the father must take certain steps to substantiate his parental rights within 30 days, or lose the ability to contest an adoption. The Prebirth Notice Statute is intended to increase the certainty of the unborn child's future by requiring the father to take prompt steps to substantiate his parental relationship and by precluding the father from subsequently interfering with an adoption proceeding if he fails to comply with the statute. It is undisputed that James did not take the steps the Prebirth Notice Statute requires within 30 days of receiving the notice. Indeed, the record reflects that although James appears to have eventually complied with the statutory requirements, he did not do so until after 30 days had elapsed. James did not file a paternity action and affidavit until 42 days after he received the notice, and he did not file with the Department of Health for another 2 weeks after that. James would therefore have lost the ability to contest the child's adoption if the notice triggered the Prebirth Notice Statute's 30-day compliance period. James argued, however, that the notice did not trigger the Prebirth Notice Statute 30-day period because the notice did not comply with the requirements the statute imposes. Although James raised 2 arguments, specifically, James argued successfully on only one of them, that the notice did not comply with the statute because it informed him that he may, rather than shall, lose his parental rights if he did not take the required steps within 30 days. The Utah Supreme Court also agreed that James's receipt of the defective notice did not trigger the running of the statute's 30-day clock. The Prebirth Notice Statute mandates that a notice shall include the consequences for failure to comply with the requirements, including that the birth father's ability to assert the right, if any, to contest an adoption is irrevocably lost. The notice that the birth mother provided to James did not inform James that his right to withhold consent to the child's adoption is irrevocably lost if he fails to comply with the Prebirth Notice Statute. Nor did it tell him that by failing to comply, he will lose the ability to assert the right to contest any future adoption, and that he will lose the right to notice of the adoption. Rather, the notice listed the steps that the statute requires of birth fathers and then stated, if you do not take these steps within 30 days of receiving this notice, you may lose all rights relating to the child, including the right to consent or withhold your consent to the adoption. The district court concluded that the notice contained all of the proper content and information required by the statute to be in such notice, but that conclusion was incorrect. By informing James only that he may lose his rights, the notice did not include information that the Prebirth Notice Statute requires, that James would lose his rights. The statute can strip a birth father of his rights only if the father is a, quote, recipient of the notice described in subsection 2, close quote, of that statute. The statute provides that the notice described in subsection 2 shall include certain information, including the consequences for failing to comply with the statute within 30 days. Without the required information, a notice is not a, quote, notice described in subsection 2, close quote, and does not start the 30-day clock for a birth father to secure his rights under the statute. While the Utah Supreme Court agreed with the adoptive parent's contention that the Prebirth Notice Statute does not mandate any particular verbiage, the statutory requirements, however, cannot be satisfied by substituting the speculative "you may lose" for definite language such as "you will lose." The Prebirth Notice Statute is intended to provide certainty by requiring a birth father to make a knowing choice to either pursue his parental rights or waive those rights and thereby facilitate the mother's announced intention to place the child for adoption. By suggesting that the consequences of noncompliance with the statute were only possible instead of certain, the notice failed to convey the gravity of the situation to James in the stark terms that the legislature has mandated. Adoptive parents also argued that the notice was factually more accurate than the notice the Prebirth Notice Statute envisions because there was a possibility that mother might not have elected to place the child for adoption. Even if the court were to agree with the adoptive parents that more speculative wording could be characterized as more accurate than the statute requires, the notice would still not satisfy the statute's express requirements. In enacting the statute, the legislature created a mechanism to shorten the generally applicable time frame for a birth father to pursue his rights. The Utah Supreme Court presumed that when enacting that mechanism, the legislature balanced the competing interests of birth fathers, birth mothers, adoptive parents, and adopted children. In striking this balance, the legislature concluded that a pre-birth notice must contain certain information to give birth fathers the ability to know and protect their interests. For example, a birth father must have the ability to determine from the face of a notice whether it starts the statute's 30-day clock running or not. In exchange, the father is prohibited from relying on any representations that the mother or third parties might make about the notice. Indeed, Utah Code Section 78B-6-106 sub 1 provides, quote, "Each parent of a child conceived or born outside of marriage is responsible for his or her own actions and is not excused from strict compliance with the provision of this chapter upon any action, statement, or omission of the other parent or third parties," close quote. Similarly, Section 78B-6-110.1 sub 4 requires that a birth father be informed of the rights that he will lose if he fails to act timely. The legislature, perhaps in recognition that words like "will lose" might light a fire that words like "may lose" might not, requires a pre-birth notice to inform a father that he will lose the statutorily enumerated rights if he fails to comply with the statute. Because the pre-birth notice did not contain all of the information the statute mandates, the 30-day clock did not begin to tick, and James's failure to comply within that time frame did not deprive him of his ability to contest the child's adoption. For these reasons, the Utah Supreme Court reversed the district court's order denying James's intervention motion and remanded to the district court.